This is OwlUp, where learning happens in minutes, not hours. For a deeper journey, explore all our courses at owlup.co. Now, let's dive in. Welcome back to How Courts Actually Work, Justice Demystified. I'm thrilled you're joining me for Chapter 4, where we're finally stepping inside the courtroom to see what actually happens during a trial from start to finish. We'll walk through each stage together, from jury selection to that final gavel bang, so you'll know exactly what's going on the next time you watch a courtroom drama or find yourself on jury duty. Let's get into it. In most criminal cases, the verdict is decided long before a jury ever sits down, because there is no jury. Yet trials still shape how we think justice works. So today, step inside the rare case that actually goes the distance and hear how every move is scripted to protect fairness. Only a tiny slice of disputes ever reaches the full on-the-record showdown, yet that inside the courtroom sequence quietly shapes how lawyers investigate, negotiate, and even write emails years earlier. By the time people stand up in front of a judge, dozens of invisible gears are already spinning, deadlines triggered, rules of evidence looming, strategic choices locked in. Think of it like joining a play at the final act. What you see on stage is the product of months of blocking, rewrites, and cuts the audience never witnesses. In this episode, we'll pull the curtain back on that final act itself, the ordered steps from selecting who decides the facts, through carefully limited storytelling, to the structured way the decision-makers argue, reason, and finally announce what happens next. Along the way, notice how small procedural moves can tilt enormous real-world outcomes. By the time everyone files into court, the stakes are sky-high, but the atmosphere can feel strangely technical, like stepping into a lab where emotion is present, yet carefully contained. Micro-routines take over, where people sit, who speaks first, how documents are labeled, when someone may stand or object. These aren't just traditions. They're guardrails shaping how stories can be told and tested. Even small choices, who's questioned in what order, which exhibit appears on a screen, how a pause is used, subtly guide attention, much like a film editor's cuts direct what an audience truly absorbs. The choreography starts before anyone says a word to the decision-makers. The court quietly decides who will sit in those chairs. In jury selection, hundreds of tiny value judgments happen in public view but coded language. Lawyers don't ask, "Will you side with the police?" Instead, they ask, "How do you feel about law enforcement testimony?" They're listening less for perfect neutrality and more for predictability. Who might cling tightly to first impressions? Who seems open to shifting their mind when new information appears? Judges filter out people who can't follow the legal standards. Lawyers try to strike those who won't. Once the group is set, the rules dictate not just what is said, but when. Opening statements are more like annotated roadmaps than full stories. You're allowed to sketch the route. You will hear from 3 witnesses. The records will show, but not drive there yet. No arguing, no dramatic speeches about what should happen. You're constrained to promising only what you have a good faith basis to prove later. Break that, and you risk objections, jury instructions that undercut your credibility, or even a mistrial. Then comes the evidence phase, where the side with the burden doesn't simply tell, but must build their version of events, brick by brick. Direct examination is deliberately structured to be slow and controlled. Mostly open-ended questions, documents introduced stepwise, foundations laid so that each exhibit can stand if later challenged on appeal. Cross-examination, by contrast, is about pressure and focus, tight, leading questions that box in wiggle room and expose gaps between what a witness claims now and what records or prior statements show. Throughout, the evidentiary rules act like a series of bouncers at different doors. A statement might be kept out because it's hearsay, then let in because it fits a narrow exception. A photo might be blocked as more inflammatory than informative. Lawyers constantly test these boundaries in sidebars and pre-planned motions, knowing that a single ruling can reshape the entire narrative path available to them. In a product's liability case about a faulty battery, that choreography becomes concrete. During selection, Someone who spent years in consumer safety work might be excused, while an electrical engineer stays because they promise to follow only what's presented. Openings sketch two rival routes, one side emphasizing design choices and cost-cutting, the other stressing user modifications and warnings. When testimony starts, the manufacturer's engineer walks through lab reports, while the plaintiff's expert dissects tiny design tolerances. A single ruling, say, excluding internal emails about acceptable failure rates as too prejudicial, can force one side to lean harder on live witnesses instead of documents. Objections pop up not just on dramatic points, but on mundane phrasing that could mislead about timing, responsibility, or risk. Step back, and the whole process resembles a tightly scored piece of music. The same shared notes, facts, can support a somber dirge or an urgent warning, depending on which theme's rules allow each side to repeat and develop. Only a sliver of cases ever reach this full, on-the-record performance, which turns each one into a kind of public laboratory. Procedural tweaks, like allowing remote witnesses or AI-assisted evidence review, won't just change speed, they'll reshape how stories get told, challenged, and believed. Your challenge this week? Follow one real trial transcript. Note where rules cut off a line of questioning, then ask, what stories never even reached the stage? Outside that scripted arena, most conflicts end quietly. A contract tweaked, a policy rewritten, an apology finally offered. The rare public clash functions like a stress test, revealing where rules hold and where they bend. As digital records multiply like unwatched security cameras, the real frontier is deciding which few frames deserve the spotlight. Before next week, ask yourself, 1. If I had to explain the difference between opening statements, direct examination, cross-examination, and closing arguments to a friend, where would I stumble? And what's one concrete example from a real or fictional case I could use to make it clearer in my own mind? 2. Looking at my own communication style, during which phase of trial procedure, opening, questioning, or closing, would I naturally be strongest, and how could I deliberately practice the one I'm weakest at in my next meeting or conversation? 3. If I were on a jury tomorrow, what specific courtroom behavior, objections, sidebars, evidence handling, judge's instructions, would most confuse me, and what's one trusted source I can read or watch today to demystify that exact step in the trial process? This was OwlUp, your daily step forward. This series continues with more chapters on OwlUp.co. Visit OwlUp.co to access the complete course and continue your learning journey. See you there!